Hello, my name is Courtney, and I will be discussing the United States versus Jeffrey Skilling case, otherwise known as Enron. So I'll start with giving a little bit of background. Enron was founded in 1985 by Kenneth Lay, who was the founder and served as the CEO until the appointment of Jeffrey Skilling in 2001. In 1999, the company began to trade commodities and became the seventh largest company on the Fortune 500 list. Although Jeffrey Skilling was appointed CEO in 2001, after a tenure of 6 months, he resigned for quote unquote personal reasons. Shortly after Skilling resigned, Enron filed for bankruptcy, and in turn, the US Securities and Exchange Commission, the SEC, and FBI began an investigation. In 2006, Skilling was convicted of conspiracy, securities fraud, making false representations to auditors, and insider trading. However, Skilling appealed in 2010, and the Supreme Court overturned the conspiracy charge, ruling the company officers would not know when and how they, the executive employees, had violated the law because this portion of the statute was being applied when anything went wrong in the company. So essentially, the charge was too broad and it was too difficult to know what deprived shareholders of honest service. As a result, Skilling received a reduced sentence of 14 years and still owed the company's victims $42 million in restitution. So I believe the Enron case had a major impact on crimes committed by businesses, especially businesses with a lack of moral and ethical judgment. This case set the precedent for future cases and of misconduct, fraud, and insider trading. In fact, it played a major role in Congress's implementation or passing of Sarbanes-Oxley Act, which sought to improve auditing and public disclosure. With this improvement, it would most importantly identify companies that were not practicing proper, for example, accounting practices. So most importantly, this case reiterated the need for corporate governance and accountability of executive members of a company. In my opinion, it's the CEO's responsibility to ensure that the company follows legal and ethical practices. In my experience, it starts from the top. If your C-suite is practicing or engaging in unethical behavior, those employees from the C-suite down will also engage in unethical behavior. So again, I do believe this case set a precedent that anyone and everyone will be held accountable when engaging in illegal activity. In conclusion, I agree with the initial ruling. So in the initial ruling, Skilling was sentenced to 24 years in prison and $42 million in restitution to Enron's victims. I don't understand and don't agree with the 10-year reduction in the sentence. So once the Supreme Court ruled against or overturned the honest service fraud, they reduced the sentence from 24 years to 14 years. And again, I don't necessarily agree with this ruling in this overturn. I do believe that he should have kept his 24 years sentence in addition to the $2 million in restitution. I think, again, this case really needed to set the precedent for anyone and everyone moving forward, that as a CEO, you hold not only sole responsibility, but the most responsibility in ensuring your organization is practicing legal and engaging in legal activity and not illegal activity.